You ever notice how every time gun owners win a little ground, New York finds another way to tighten the screws? That's exactly what's happening right now. A major case challenging New York City's rifle and shotgun permit scheme just got knocked down. Not because the arguments weren't solid, but because the courts decided to dodge the fight altogether. Here's the deal. The Supreme Court was asked to step in on an emergency basis to block the city's permit system while the lawsuit played out. They refused, and that opened the door for the Second Circuit Court of Appeals to go one step further and dismiss the whole case as moot. Translation: they said the guy who brought the lawsuit doesn't even have a fight anymore, simply because the city decided to hand him a permit after he sued. Now, if that sounds shady to you, you're not alone. This case shows how states and cities can play games with the courts, issuing one-off permits just to avoid a ruling on the bigger constitutional question. That's dangerous, because the real issue isn't whether one guy gets his permit. It's whether millions of law-abiding Americans can be forced into a discretionary licensing system that flat-out ignores the Supreme Court's Bruen decision. So in this breakdown, we're gonna unpack exactly what happened, why it matters for the Second Amendment, and how it could end up back in front of the highest court in the land, whether New York likes it or not. Let's set the stage. New York City has one of the most restrictive firearm licensing systems in the entire country. If you want to own a simple pump shotgun or a bolt-action rifle, you can't just pass a background check and walk out with your gun like you can in most states. No. In New York City, you need a special permit issued by the NYPD. And here's the kicker. That permit process isn't objective. It's what they call a discretionary system. That means the police department has the power to say yes or no based on their judgment of your good moral character. Sounds vague? That's because it is. There's no clear checklist, no simple standard. One applicant might be approved, another might be denied, and both could have clean records. It's basically a permission slip system where your constitutional right hinges on the opinion of a licensing officer. This is where it gets dangerous. In 2022, the Supreme Court issued a landmark ruling in NYSRPA versus Bruen. In that case, they struck down New York's requirement that handgun permit applicants show proper cause, basically a special need to carry for self-defense. The court made it crystal clear: you don't have to justify exercising a constitutional right. The Second Amendment is the justification. So what Joseph Schroer did was simple but bold. He looked at the city's rifle and shotgun permit system and said, "Wait a minute, this is the same thing. You can't make me prove good moral character just to own a long gun when the Supreme Court already said discretionary licensing is unconstitutional." That's how Schroer v. City of New York was born. It wasn't just about one man trying to get a permit. It was about exposing a system that potentially violates the rights of thousands of New Yorkers every single year. And here's the kicker. While most of America sees owning a shotgun for home defense or a .22 rifle for small game as the bare minimum, in New York City, those same firearms require jumping through bureaucratic hoops that can take months, sometimes over a year. It's a system designed not to regulate responsibly, but to discourage ownership altogether. When Schroer first filed his case, a lot of people thought it would be dead on arrival. After all, New York's courts have a long history of siding with the city on gun control. But to everyone's surprise, the district court actually gave him a win. At least, a partial one. The judge looked at the good moral character requirement and compared it directly to the Bruen ruling. Bruen had already established that states can't use discretionary, subjective standards to decide who gets to exercise their Second Amendment rights. So, when New York insisted that every rifle and shotgun owner pass a vague moral character test, the court said, that doesn't fly. They granted an injunction blocking enforcement of that part of the law. For a moment, it felt like history was repeating itself. Another big piece of New York's gun control scheme falling apart under constitutional scrutiny. Gun owners saw it as a breakthrough. If New York City couldn't enforce its moral character rule, thousands of applicants who had been waiting in limbo might finally see their rights restored. But New York wasn't about to let that happen. The city immediately appealed to the Second Circuit Court of Appeals. They asked for an emergency stay, basically hitting the pause button on the injunction, while the case worked its way up the ladder. And sure enough, the Second Circuit granted that stay. At that point, Schroer's team took their fight to the highest level. They filed an emergency application with the Supreme Court, asking the justices to step in and lift the stay. Their argument was straightforward. This isn't a new question. You already ruled on this in Bruen. New York is trying to recycle the same unconstitutional playbook with different wording. We need relief now, not years down the road. The request landed on Justice Sotomayor's desk. She handles emergency applications from that circuit. And when the full court reviewed it, they ultimately declined to intervene. No explanation, no breakdown of votes. Just a denial. And here's where the domino effect started. With the Supreme Court refusing to step in, the Second Circuit was free to take the case and steer it however they wanted. They could have looked at the constitutional arguments head-on. They could have tested the good moral character standard against Bruen and given us a ruling that clarified the law for every city and state. But instead, they ducked. They dismissed the case as moot, claiming that because Schroer eventually got his rifle and shotgun permit during the litigation, there was nothing left to fight about. That's like a football team faking an injury timeout just to stop the clock. Technically legal, but it kills the spirit of the game, and in this case, it killed the lawsuit before the real constitutional questions could ever be answered. So let's talk about this idea of mootness. The Second Circuit basically said, look, Mr. Schroer already got his permit, so the issue's resolved. No need to go further. On the surface, that might sound logical, but if you scratch just a little deeper, it falls apart. Because here's the reality. This lawsuit wasn't about one man. It was about a broken system. Giving Schroer a permit didn't change the fact that thousands of other law-abiding New Yorkers are still trapped under the exact same unconstitutional rules. The problem is bigger than one piece of paper. Schroer's lawyers hammered this point. They argued that the city played a game of legal whack-a-mole. The moment they saw the case gaining traction, they handed out a single permit to the plaintiff. Not to fix the system, but to kill the lawsuit. If that tactic is allowed to stand, every city with restrictive gun laws now has a roadmap. Stall the case, throw the plaintiff a bone, and make the lawsuit disappear. And here's why that's dangerous. It sets up what lawyers call a chilling effect. If you're an ordinary gun owner thinking about challenging an unconstitutional law, why even bother? The city can just cave to your individual claim, hand you a permit, and leave everyone else twisting in the wind. The law itself never gets reviewed, never gets struck down, and the bad system stays alive. This isn't just theory. We've seen similar strategies in other states. In California, for example, some counties deliberately dragged their feet on concealed carry applications. The minute lawsuits were filed, they'd quietly issue a permit to that specific person while keeping the same hurdles in place for everyone else. Illinois pulled similar maneuvers when their FOID card system came under fire. These aren't isolated incidents, it's a pattern. The courts should recognize that. There are already legal doctrines that deal with this kind of abuse. Normally, if a government actor moots a case just to avoid judgment, courts will still hear it. Or if the issue is capable of repetition but evading review, meaning it's likely to happen again to someone else, the courts usually step in. Schroer's team made those arguments. They said, look, the city can yank his permit at renewal or deny someone else's tomorrow. This injury is ongoing. But the Second Circuit brushed that aside. They said there's no proof New York acted in bad faith. No proof they'll revoke his license, and therefore, no case. That's not just naive, it's reckless. Because history shows, given the chance, these cities will absolutely keep playing games to protect their gun control schemes. At the end of the day, the fight here is about more than New York. It's about whether courts are willing to actually confront the constitutional question or let states and cities slip through the cracks with procedural tricks. If this stands, it could embolden other jurisdictions to double down on discretionary licensing, knowing they can dodge accountability with the same playbook. That's why so many in the 2A community are watching this one closely. Because if the Supreme Court doesn't eventually take it up and rule on the actual merits, we're going to see this movie play on repeat. And every time, ordinary gun owners will be the ones paying the price. So that's where things stand right now. A challenge that could have reshaped New York's entire permit system got kicked down the road. Not because the arguments lacked strength, but because the courts looked for the easiest off-ramp. Think about what that means. If one city can dodge a constitutional challenge simply by granting a permit mid-lawsuit, then nothing stops other states from running the same play. California, Illinois, New Jersey, you name it. All of them could sidestep accountability with a little paperwork shuffle, leaving the bigger Second Amendment questions unanswered. And that's the real danger here. The Second Amendment was written as a guarantee, not a suggestion. It doesn't say, "shall not be infringed," unless your city decides you lack good moral character. It doesn't allow governments to hand out rights like they're passing out hall passes. This isn't about one permit. It's about the principle. So where do we go from here? Chances are this fight isn't over. The case could head back up the chain, maybe even land on the Supreme Court's desk again. And if it does, the justices will have a chance to finally answer the question head-on. Can a city keep hiding behind vague, discretionary standards? Or does Bruen apply across the board to every licensing scheme in America? I want to hear from you guys. Do you think the Second Circuit was just ducking the issue? Or do you think they had a point saying this case was moot? Drop your take down below. I know this community has some sharp opinions on it. And as always, make sure you like, subscribe, and drop a comment down below. Stay sharp.